I'm not sure how that happens. There were 9 scores in whole between 71 and 80. And we still sent it back for the court to consider additional evidence, including adaptive functioning, correct? What Justice Alito is saying is states could do something like he suggests, but is that constitutionally required?
I think the difference, though, is—
Answer my question. Would states have to do it that way, or could they do it now in whatever way they thought, one of the 5 ways suggested by the other side, or the way they're actually doing it now?
The answer is uncertain for the reasons I was explaining with Justice Kagan. And I can't, I'm not good enough at math to do this on the fly, but the basic idea is that if those collective scores do not produce a range that even grades
Has
70,
any state
I don't think
adapted that measure?
bar.
Has any state approached the issue that way with multiple scores?
I don't think so. I think
Did Dr. King approach it that way below?
In part, I think he focused on IQ and said that it did not fall below 70, and then also said that the other evidence on the other side of the ledger wasn't strong enough to show any other form of disability either.
What I thought he did was exactly what all the experts did, is 3 of the 5 fell within intellectual disability, and then he relied on adaptive functioning to say he thought he was not intellectually disabled.
Let me make one quick point, just addition to this, is that what you won't find in any of the expert reports is a conclusion with respect to what Alabama law asks. None of them found that respondent's true IQ was likely 70 or below. So finding that respondent did not satisfy his—
I'm sorry, who didn't find that?
No expert in this case. You won't find any—
Wait a minute, that's what they did say.
No, it's
2 of them, at least 2 of respondents' experts found he was intellectually disabled. That was the finding the district court made.
It depends what definition you're using. The experts were using clinical definitions that are distinct from Alabama law.
I don't disagree with you, but the district court was following Alabama law. These things are not statutory. Most of these, the very few, maybe Oklahoma is now, where 1 score above 76 disqualifies you. I don't know how that's not different than the 1 score above 70 situation might be, but we'll look at Oklahoma when it comes to us.
Sure. The only one thing I'll add is that I don't think the district court was following Alabama law, because as my friend emphasized, I think a very telling point is that you will not find a single sentence in anything the district court wrote that said respondent's IQ is likely 70 or below. We think that they were laboring under—
Oh, is that what you think they did wrong?
I think that where they're trying to get at the start is there's 2 problems. They misunderstood the standard for a possibility idea from the 1 low score rule.
That was only the 11th Circuit who said that. The district court certainly didn't say that.
But then the basic part 2 is returning to what Alabama law is, which is a numerical inquiry. Does the evidence show that you've been able to drag down the IQ scores below 70? There's no engagement with that. The basic idea—
But that was never argued by Alabama.
Oh, no, it was one of their leading arguments, which was that you did not consider the totality of the evidence. And when you're trying to figure out whether the secondary evidence drags
Counsel,
the IQ down—
that's all right, I'll stop. But that's attributing to one broad statement a specific argument that I don't see. Where did they say that the adaptive functioning should be ignored because the cumulative effect of the score showed he wasn't?
It's 2 sides of the same coin. What it's saying is there's no need to move on to other stuff, because here respondent hasn't even carried his initial burden of showing it will do any good.
All right,
Thank you. Justice Kagan.